Hello there, and welcome to another edition of the Disability Law Show. Good to have you along for the half hour, I hope. John Scholes here, James Fireman, Tamar, Agopian, both from Samfiru, Tumarkin, LLP. Want to reach out to either at any time, you can do so. The phone number, 1-855-821-5900. Email address we always go to anytime as well. And on the show, help@disabilityrights.ca. I'll give you some more contact information and websites you can use at your leisure at any time a little later on the show. We always have a main topic too, and this week it is what you should know about long-term disability benefits and chronic pain. That is coming up, so stick around to it. We always start off with the week that was, our case of the week. Tamar, it's your kick at the can, my friend. What do you got?
It is my kick, and so my kick goes to a case that came out actually in Ontario against one of the larger insurers called Manulife, and the plaintiff in that case was DEC. And so, John, I want to preface this opening salvo just by simply saying that there are so few cases that come out in our disability realm across the country, in all of the provinces that we practice in, that anytime a case does come out and actually sees through trial, we're all sort of looking at it, we're all reviewing
it. It's like an
it.
eclipse. Wow.
Well, and look, and
a little bit rarer.
Yes, exactly.
And you don't necessarily need those glasses to review them, right? But there's always some important takeaways, and we're always looking at trends and obviously trying to stay ahead of the law. And so this case, really the focus on it, from my perspective anyway, is a very technical issue, and one that really deals with the idea of applying for long-term disability benefits and making that application whether or not you've applied for short-term disability benefits. Now, in this case, the court found in favor of the claimant on this issue. I'm going to try and break it down for our viewers. The point was this: the claimant had applied for short-term disability benefits and had been approved for a period of time, and that same insurer had approved it, but then took the position, because the claimant hadn't applied for long-term, that they weren't eligible for long-term disability benefits because that application had not been made. So in instances like that, there is a law that we can rely upon. It's a concept called relief from forfeiture. I'm not going to get into where it is in the legislature, but at the end of the day, what it means is that you can ask the court for essentially forgiveness, to say, court, look, I'm sorry, I didn't comply with this technical requirement to make this LTD application, but will you permit me, in the absence of anything else, for me to move forward and have the insurance company consider my claim anyway? The insurance company had said no, obviously, and they actually had litigated the case all the way through. It was a long trial, and in the end, there was a whole host of other issues we can touch on, but on this point, the court agreed with the claimant and said, you know what, we're looking at this, it's the same insurer. We don't expect the insurer to have taken any different position on long-term if they'd already communicated some form of a denial for the short-term. And so we actually think this isn't, it's imperfect compliance as opposed to non-compliance. And so we are going to grant the claimant this relief. But the point that I'm bringing up is this. We routinely will give the advice, James and I and other members on our team, make that LTD application, no matter what.
Just do it.
Just do it. Even if the law is on your side on this issue, and it is, and we will provide that advice, why give the insurer the opportunity to use these technical reasons to deny your claim? Surely they have many other reasons they're going to throw at you, and so why give them this extra ammunition to say, you don't even get out of the gates, you didn't apply? And where we see this a lot, John, is when people are trying to actually transition from short-term to long-term, and you have the same insurer, sometimes the insurer isn't paying the short-term, and so they're incentivized to actually deny the long-term claim and use these technical reasons, because if they had to actually look at it, and maybe there's legitimacy to the claim, they would have had to approve it, and then they have to pay the disability benefit. And we know with these profit-making machines that these insurers are, they don't want to do that. And so I think this case helpfully highlights this issue, and it's almost a cautionary tale as well to say, look, don't even get there, make that application, or at least write to the insurer and say, hey, you've looked at my short term, I see that you've denied, but at this point I should have been approved for long term, what say you? And even an email saying, well, we're not even considering it or you're denied, will be just as sufficient to then close the loop on an issue like this for the insurer to come back later on in litigation to say, well, you never applied, so you're not entitled to the benefit.
James, you look like you're champing at the bit to say something.
Oh, I had one point, Tamar just made it. I actually do have something else I want to talk about.
Okay.
So a couple years ago, Siobhan gave me this nice promotion, maybe the national practice leader, which means very little, but one of the things that I do have to do as part of that is review client surveys that come into the firm. So anytime we finish a case with one of our clients, they will complete a survey. It's for internal purposes. We just want to make sure if there's anything that we can improve on, that we're aware of it. And as the group leader for disability, I get all of those from everybody in our group. And I say it's an easy job because all of the lawyers in our group are very experienced, and the issues are exceedingly rare, if ever. And I would be lying if I said I was always right on top of reviewing them, because it just isn't something that is ever anything I need to really pay attention to. So this morning, I went through, I think, about 250 of these from the last couple of months, okay? There was a lot of them. And across the board, they were all great. But I thought I would pull out a few of them from one person in particular, sitting right next to me, Tamar. Across the board, every...
Did you know this is coming?
She didn't know this was coming. She's got no idea, so we're embarrassing her on live TV here. Across the board, every question, so there are 3 questions where you're rated 1 through 10. How likely are you to recommend? How is your lawyer's communication? How is the legal assistant's
10 being
communication?
you bet, 1 being not ever again.
10, 10, 10. Every single one.
You.
A couple comments, though. There's one question where they say, what is the most important reason you would or would not recommend Samfiru Tumarkin? I picked out a couple I just wanted to share, comments that were made. I've got nothing but praise to Tamar and her crew. They made an extremely stressful time turn into a positive. Great work. They actually care about you. Tamar and Linda, Tamar's assistant, were absolutely amazing. Tamar is such a brilliant, competent, trustworthy, industrious, and honest lawyer. She ensured to explain everything to me from beginning to end. No question was too bothersome. Rather, she'd earnestly entertain my questions, thoughts, and explore everything I had to say. I immensely appreciate the dedication and long hours of reading and research she put into my case. She truly got to know me as a living, breathing person and handled my case as such. Wow. Process was easy, and they get results. Short and to the point. Yeah. One more. My experience with Tamar was consistently reliable, prompt communication, lots of clarifications as I needed, no errors. So there you have it.
Look at that.
Perfect across the board. Well done, Tamar.
Thanks,
10 out of it.
James.
You're the Mary Lou Retton of
that.
disability law. For all those listening who are
that.
not of our age, I was a gymnast back in the United. Never mind. Anyway, well done. Pocket disability lawyer. What do you think about it?
Well, look, I mean, I appreciate James's comments. We work as a team. And again, these are all tools, right? Our client surveys, our pocket disability lawyer, all of the things that we do on our radios and our shows, because the idea is to try and get as much information out there to people as we can. And this tool is one that's completely anonymous. It's a drop-down menu. You can just plug in some information and see whether or not it's worth speaking to one of us. But if you don't want to, you can just say no, close out the browser, and we're none the wiser. But I really do think that it is a good starting point for people when they're not really sure what to do with their disability claim, and really whether or not it makes sense to take that additional step to talk to one of us.
PocketDisabilityLawyer.ca, that's how you find it. Want to get to a phone call? This would be from one of our radio shows, Ontario, possibly Alberta, maybe way out in BC as well. Came in from somewhere. It's a good call. I know you guys want to hear it, and we'll dissect it and go from there. So here it is, a first phone call of the show. Listen up.
So I was on an extended leave of absence from my employer. I was also a member of the board of directors. I was a member of the board. At some point, I was the chair of their Human Resources and Governance Committee. Purely voluntary. It was a small commitment of time every month. I'm wondering, does this affect benefits if the LTD provider was to find out I was doing that?
Okay, the phone call was a little bit garbled, but just in case you weren't able to hear it, this gentleman called in, and his concern is that he's been doing this voluntary work on a board of directors. And he's worried that if his insurer finds out about it, that could impact his benefits. And to some extent, he's right. It could impact his benefits. Whether or not it does is a question of the actual factual circumstances. The devil is always in the details. So I've sat on a board of director for my kids' daycare, and that was once a month for 1 or 2 hours, and more often than not, they actually got punted to the next month. If it's something like that, is that really going to impact your claim? Almost certainly not. Unless you're telling the insurer, I can never leave my house, and you are in fact leaving your house to do this, and that's going to damage your credibility. Short of that, as long as you're not doing anything that you've said that you absolutely cannot do, It really just depends on what it looks like in totality. So if sitting on the board of directors is a more onerous task, if you're meeting once or twice a month and it's 4 or 5 hours and you're perhaps the chair of the board of directors and you're directing how everything is going, and in between you're doing a lot of preparation, sure, the insurer is going to look at that and say, well, look at all of these things that you're doing. We think this shows that you might be able to go back to work. But something less than that, maybe not. Whether or not an insurer is going to take that information and then say, we think you can work, even if you clearly can't, is an entirely different question. Their threshold for what will satisfy them as a justification for terminating benefits is usually quite low. Having said all that, my strong advice is to not keep this from them. It is much, much worse if it looks like you've been hiding something and then they find out you've been on this board of directors, even if it's completely innocuous, because then they may not believe what you're saying, and frankly, they might have a reason not to believe you if you haven't been upfront with them. So my advice is to disclose that. If you're sitting on a board of directors, disclose it. And be careful in what you're doing. And if you're not sure whether or not it's something that might impact your benefits, certainly you can call us for an opinion. I would also talk to your doctors and see whether your doctors have any issue, given whatever your disability might be, with you making that sort of time commitment and whatever the travel issues might be, if it's a physical disability, to going to these board of directors meetings as often as they occur.
Okay, let me ask you this, Tamar. You made a good point, physical disability. Just assuming that, say this is a mental disability.
Right.
Maybe this is a therapeutic thing to get out and socialize with these people on the board, and it's by the doctor's orders. I mean, that might be a bit of a reach, but is that possible? He's been told to get out there once, twice a week.
How many board of directors have you sat on?
That's a good point. Right.
Look, you're right, John, you make a good point, but I wholeheartedly agree with James on this, which is that it's not necessarily a right or wrong, and it shouldn't be. Much like the definition of disability, people just assume, oh, total disability means I'm laid up in bed every single day. Well, no, it actually doesn't mean that. I think where the level of activity here is really the key issue, because we do routinely see insurers cherry pick information and attribute function, right? They're obsessed with this idea of, if you can do A, it must mean you can do B. So if you can be on this board and even attend a handful of times a year, but be cognitively available or have mental health capacity to be able to attend in the presence of other people, let's say, the context is really important here, then it therefore must mean that you have the emotional acuity, the mental cognitive ability to do whatever occupation, whether your own occupation or any occupation. So I think that the advice that we've provided, the comments around this are really important. And I also think understanding your policy is super important. So what does the policy say about quote unquote work? Most of them won't talk really about volunteer work, but is this really work? And so you kind of want to hear from a disability lawyer, is what I'm doing, in that threshold where the insurer might use this against me? And in the context, again, as James has said, what is the doctor recommending? What is the doctor advising? Because if it is a mental health disability and this is a good outlet for you, then by all means, if it's part of your recovery and the insurer is aware of it and your medical team is aware of it, then I wholeheartedly encourage it, as long as everyone's on the same page that this is part of your profile on a day-to-day basis and still disability.
We could talk about this one all show, but we got to take a short break. I want to remind you as well, you want to reach out anytime, you can do so. Disabilityrights.ca to find a radio station in your market which will carry our show. That said, we'll take a short break. Lots more coming up on the Disability Law Show. Hang in there. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Disability Law Show. My name's John Scholes. I just host all the brains of the operation right there. James, Fireman, Tamar, Agopian. Reach out to either or both and their teams. Phone number is 1-855-821-5900. You can always use the email help@disabilityrights.ca. Every show, we have a main topic we discuss in the second segment, so that's what this is now. Guys, what you need to know about long-term disability and chronic pain, how they work together, and what you got to know. First one is this, James, chronic pain can be difficult to diagnose. What do you think?
I'm going to ask Tamar.
Okay, let's ask Tamar.
Yes, it can be difficult to diagnose. So look, this is the classic subjective objective, right? We see this a lot. Chronic pain is one that develops over time. It takes time to diagnose, and it doesn't necessarily have a one-size-fits-all in terms of treatment, because it's not one of these conditions that you can see on an MRI or an ultrasound or an X-ray. There are diagnostic tools, absolutely, that may help to explain the source of pain, or perhaps even try and address some treatment options. And again, we're not doctors, but just having been familiarized with enough of these cases that we deal with on behalf of these claimants, we understand this. But it's also one that is really subjectively reported for this exact reason, is that it can vary from person to person. It can vary even in the same individual from day to day, and it can impact your body in different ways and also have add-on conditions. It's not just necessarily chronic pain, because most of the literature will say that it can also have add-ons to mental health components as well. And so because of all of that, there is some complexity to it, and it makes it that much more difficult for doctors to understand and report, and also to refer you to the right clinics and to get the treatment that you need. And so the starting point, though, is to actually speak to your doctor and making sure that all of those symptoms are well documented, and that at least as a starting point, you're having that conversation with your doctor to say, hey, the pain's still there. Hey, doc, it's preventing me from doing these 3 activities. Can you help me out here? What is it that we can do? So that that documentation can then build along the lines of, well, am I then going to initiate the disability claim? Where am I at in that process? Am I capable of working? But it really does start with that conversation with your primary treating doctor to say, this is what's happening, this is what I'm experiencing, let's do the testing, let's investigate, and then maybe refer me off to the right specialist for further treatment.
I want to send the second point to you, James, about LTD and chronic pain. It's very important, as a matter of fact, to keep updated medical documentation detailing your condition and treatment. What do you think?
I'm going to pick up on a word that Tamar just used, which is subjective. Chronic pain is inherently a subjective condition. Sure. It is about your experience of pain, and it becomes ingrained based on long-term injury, long-term symptoms from an injury, pain. Because of that, because it is a subjective condition, if you are disabled because of it, you need to ensure that your credibility is unimpeachable, that everything that you say can be supported, and that there is going to be medical records that show that you have had these complaints, that you've had these issues over time, that it isn't something that you're just every time you're interacting, let's say, with the insurance company, you're talking about it, but it's not something that you're talking about with your doctors, with your physiotherapists, with your chronic pain specialists, and they exist, and they're very important in the context of any litigation, whether it's personal injury or disability that involves chronic pain. So it is critical that you're going to get those supporting medical records. And because credibility is so important, it's also really important that you are upfront and honest with your insurer when you're dealing with them. I always say you have to be very careful in dealing with your insurer, and I'm certainly not backing off of that. But you also want to make sure that you're not telling your insurer things that are not in fact the case. Don't tell them that you're in bed 5 or 6 days a week if you're not. If you are out and about, then you're out and about, and that's okay. Your claim is whatever it is. Because if you tell them, and they're usually going to, if you have a subjective pain case, a chronic pain case, they will typically ask you at some point to provide them with answers to a questionnaire. Sometimes they'll ask you to keep a daily log of your symptoms. And what they'll do often is they're going to hire an investigator to do surveillance on you during those periods to see if what you say is going on is in fact what is going on. Whether or not what you're doing would support a disability is not necessarily the issue. The issue is, are you being honest with it? Because if you're not, even if the thing that you are being dishonest about doesn't mean that you can go to work, it does mean that your credibility has now been impeached, that they cannot trust you anymore. And for good reason, they'll say, well, if you lie about this, why should we believe you about that? And that's a pretty fair question as far as I'm concerned. So you have to make sure that you're not opening up any questions that relate to your credibility. One other point that I do want to make in terms of ensuring you have good records as it goes along. What can happen sometimes with chronic pain is something called central sensitization. It's not common, but when we see it, it's a very significant diagnosis. And what it means, somebody who has chronic pain and has had that condition typically over a long period of time, often the experience of pain itself can become completely divorced from the original injury, to the point where even an innocuous external stimulant, like just somebody giving you a hug, and let's say it was like a condition of a completely different part of your body, even something as innocuous as a hug is going to set off pain where you would never expect it, because it actually changes the way your neurons fire and the way that your brain works.
All that stuff, yeah.
All of that. And so it becomes a very difficult condition to treat at that point. So if you are not documenting your pain on a regular basis, is something that doctors are going to have a difficult time picking up if it turns into that, or recommending the proper treatment to avoid getting to that point.
Right. Get to one more point on this one, guys, when it comes to long-term disability and chronic pain. Tamar, this one's for you. Insurance companies often deny chronic pain LTD claims despite support from a treating doctor. No, come on.
And so this really is the heart of these chronic pain cases, is this idea that insurers come at it with this high degree of cynicism, this obsession almost to have everything documented and to have it justified objectively, quote unquote, so that they then release that monthly benefit month over month. And these types of claims, chronic pain, the central desensitization that James was mentioning, these kinds of conditions, they don't fit that model. It doesn't fit that model, and because it doesn't, you have a higher degree of these types of claims being denied by insurers. And so, what can you do in circumstances like this? And exactly the advice that we've given throughout is to document, to be accurate, to protect your credibility, and to demonstrate the consistent level of function throughout, whether to your doctors or to the insurer, so that that profile then is, pretty consistent, pretty well documented, and pretty even keeled. And look, if the insurer is going to deny the claim, cut you off down the road after accepting for a period of time perhaps that you've been disabled by this condition, well, we know, and trust me, they know, that these conditions don't necessarily improve over time. It almost becomes the norm from these kinds of individuals, which is why insurers are so aggressive in denying these kinds of claims. And then it will really be incumbent on a disability claimant to hire the right lawyer to pursue that legal claim when the insurance company is saying something that just doesn't make sense, which is, it's not objective, it's not real, it's not disabling, and therefore we don't think that you're entitled to disability benefits.
Covered nicely, guys. Let's take a short break. We'll bounce into an email after this, and send along an email anytime, by the way. help@disabilityrights.ca. More of the Disability Law Show is on the way. Stand by. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Thanks for sticking with us. The Disability Law Show. James Fireman, Tamar, Agopian. Reach out anytime by phone. We'll start there. 1-855-821-5900. Email is help@disabilityrights.ca, which is where we're going to go right now, guys. We get an email in to wrap up the show today. Kevin says, I've been receiving LTD for over 3 years and CPP disability for the last 10 months. Recently, my LTD insurer sent me for an independent medical exam. Their physician agreed that I'm disabled, but recommended treatment my own doctors feel would be unhelpful. Can the insurer cut me off if I do not comply? What do you think?
Well, first of all, there's a difference between can they cut you off, which is always yes, versus would they be justified if they cut you off? That is a different question, and that's really what I'm going to focus on here. So first of all, what strikes me about Kevin's email is this is almost certainly a very strong claim. He's been on disability for 3 years, meaning his insurance company has agreed for 3 years that they have to pay benefits because his disability meets the test, even beyond the 2-year change of definition. He's also been getting CPP disability, which if you watch our show, you know means that they've passed a more onerous test than the LTD test that is decided by the federal government. And he's gone to an independent medical exam paid for by the insurance company, and the doctor said, yeah, you're disabled. So this is out of the gate a pretty strong claim. Now, what happens in this scenario where that independent doctor, has said, okay, you need this treatment? Well, if you don't get that treatment, almost certainly your insurer will cut you off, almost certainly. What Kevin says, and maybe I'm parsing words a little too carefully here, but what Kevin says is that his own doctors feel that the treatment recommended by the IME doctor would be unhelpful. Unhelpful isn't necessarily the same thing as harmful. Those are different concepts. So if you've got a knee injury and the doctor says you should do shoulder stretching, well, that's unhelpful, but who cares? Right?
It's like me helping you with math.
If doing those shoulder stretches is going to get you to continue getting your benefits, even if it's unhelpful, sure, do them. Like, why not? But if it's actually going to be harmful, then that's an entirely different question. So if it's going to be harmful, if your doctors are saying, no, this is some Band-Aid your insurer wants you to put on to get you back to work, but it's going to hurt you long term and it's only going to be a temporary fix anyway, then I wouldn't be at all interested in doing it. And the reality is that even if you get that treatment, they're going to cut you off once you're done that treatment anyway. So whether or not you comply, it's coming sooner or later in all likelihood. If it is the case that the treatment that they're recommending is in fact harmful, your doctors tell you this is a bad idea, this is going to harm you, you need to get that in writing. You need to get your doctors to review carefully the treatment that's been recommended and say exactly why this is the wrong thing for you to do and what is likely to happen if you're forced to do it. Get that in writing and put that in front of the insurance company. Hopefully, if anyone there has any sense at all in getting that, they'll say, okay, maybe we need to look at this again, or maybe we didn't consider this factor or that. Don't hold your breath, though. Don't hold your breath, because they're probably going to say, okay, well, our doctor said you got to do it, and I don't care what your doctor says. We've got a justification. We're going to cut you off. If that happens, and unfortunately there's a good chance it will, then you give us a call, because that is certainly not justified. And if they are forcing you, and by forcing I'm saying removing your benefits if you don't do it, to get treatment that's going to be harmful, they're exposing themselves not only to having to pay the benefits that they should be paying all along, but also to punitive damages for acting in bad faith and for putting your health in jeopardy, which is also general damages. So there are a lot of things that we can do with that from a legal perspective, even if your insurance company happens to cut you off.
But it's good, at least he's got the CPP disability for now, right?
He does, and that will have some ongoing benefits for him, and it is helpful leverage. But I want to echo what James is saying, which is these are great cases for us, because most of these cases we don't see inside of a courtroom, because the insurer's position on denying on the lack of appropriate treatment is not a great position for the insurer to be in. And so I wholeheartedly agree with James on this. If Kevin is denied in circumstances like this, or someone's watching and they're thinking, I'm kind of in the same boat, what should I do? You always use the reasonableness barometer, and if it doesn't make sense that the insurers cut you off, it usually probably means that it doesn't, and there's a good basis for a claim to challenge for more benefits.
Good stuff, guys. We're done for another show. Reach out anytime, 1-855-821-5900, disabilityrights.ca. We'll catch you next time on the Disability Law Show.